4 arms, so I will wisely remove my terrible towel mask from my argument.
Good call.
May it please the court. There are at least 3 critical points which I want to impress upon the court today as to why the writ of prohibition should be denied and Judge Bailey's order of consolidation affirmed. First, petitioner asserts that this case is a classic reason why the same judge should never preside over both the declaratory judgment action and the underlying tort litigation, or at least in a consolidated fashion. And I believe that's on page 14 of their brief. That statement could not be further from the recognized practice of this court and our state courts. Since at least 1989 in Christian v. Sizemore, in which this court held that a declaratory judgment action seeking insurance coverage could be included in the complaint, the underlying tort complaint. Since that time, it has been common practice and routine practice throughout this state that declaratory judgment actions for insurance proceeds or insurance coverage is indeed included with the underlying tort litigation. Now, the reason why there's very little case law under Rule 42A or B regarding this is normally you don't have to raise it for that very reason, because most of the time the plaintiff either includes the declaratory judgment count in the underlying tort complaint, or the defendant, when they file an answer, assert a third-party complaint against their insurance company and seek declaratory judgment. In fact, defendant CMC has done that in this case in response to one of our amended complaints and has brought in Zurich, which is one of its insurance companies in this case, and that is proceeding in front of Judge Bailey without any objection.
Well, no matter which judge it's in front of, if the consolidation is reversed, if it's not reversed, should the petition for declaratory relief be heard first by Judge Bailey?
Yeah, and actually that was one of my points coming up, but I'll try to address it now briefly.
Because I don't hear Mr. Williams complaining if these matters stay with the same judge. I think I heard him say, he can correct me if I'm wrong, he doesn't care which one handles it, but he thinks that the petition for declaratory relief ought to go first.
Well, then I will point the court to Exhibit 21 of the appendix that Mr. Williams prepared, which is the transcript of the hearing in front of Judge Bailey, November 22nd, 2019, I believe. After they argued about whether consolidation was appropriate or not, and Judge Bailey determined or indicated she was going to rule for consolidation for purposes that I'll discuss later on, she actually, in response to Mr. Williams' concern, gave out dates for hearings in February and March earlier this year for the DEC action motions to be heard. And at that hearing, I believe March the 3rd at 9 a.m. was determined to be the date that everything would be heard. And I believe that is actually on page 821 of the appendix, which is page 39 of the transcript. And actually there's discussions from page 17 of the transcript all the way through there where there's talk about needing to have this hearing at some point and her willingness to do so. Now, apparently what happened after that was that plaintiffs submitted a proposed order in light of the judge's rulings, and the petitioner contacted the court by writing, which is also, I think, on the record, saying, we would like the court not to enter the plaintiff's proposed order, but to do your own order setting forth findings of fact and conclusions of law, because we might consider filing a writ of prohibition. So that led to a further delay, whereby the writ of prohibition was actually not the order. I mean, the order itself was not issued by the court until March 3rd of 2020. So at that time, the hearing which had been scheduled for the DEC action motions was I guess made a status conference where all the pending issues were discussed, and another hearing date was set for May 20th, I believe, which would have addressed all the DEC action motions voluntarily by Judge Bailey. However, it appears by correspondence that in light of their decision in late March to file this writ of prohibition, as well as the emergency order of this court in May due to COVID, they decided not to pursue those hearings and instead to pursue with a writ of prohibition. So I think if you look at the record which has been compiled, it will show that Judge Bailey was willing and able to hear the motions. And perhaps during that hearing, they could have convinced her that at least part of the rulings could have been made then, and maybe some would have to be stayed for reasons I'm going to discuss as we go along.
What about the Marks case? Does
sorry.
that not indicate, the Marks case
Yeah, the
indicates
Marks-
that you have to base the
Yes.
coverage or lack thereof based on the allegations of the complaint?
Yes, and the Marks case, I believe it's distinguishable. And for instance, and let me talk a little bit about Christian versus Sizemore first to
Okay.
explain, if I may. In Christian versus Sizemore, the court considered in reaching its conclusion for the purposes, the remedial purposes of a declaratory judgment action. It also looked at case law discussing Rule 20 joinder issues. One of the cases, I think, was Anderson versus McDonald. And then it also looked at cases addressing Rule 42. And it specifically noted that Rule 42C provided a means of bifurcating the insurance issue from the underlying tort, so therefore any prejudice could be removed from the insurance company being incurred. The court also noted that such a practice would support judicial economy and efficiency, and it prevents the need for multiple lawsuits occurring before different courts, which we all know can result in inconsistent rulings and judgments. Now, inherent in that ruling, because the court looked at Rule 20 cases and Rule 42 cases, implicit in that ruling is the fact that the court found that these declaratory judgment actions and the underlying torts have common questions of fact or law or involve a logically related transaction. Now, the only cases I think the petitioner cited in support of their argument, the first one was the State Exeral Energy Corporation of America versus Marks. As he admitted, that was a Rule 20 case, not a Rule 42. Rule 42 is not mentioned in it. But I think there are two other even more important reasons why that case is distinguishable. One, that was a med provision DEC action. And the court stressed that there was no common issue of fact or law that needed to be resolved because the medical pay provision, if it was in the policy, they had to pay it. It didn't matter which driver was at fault. It didn't matter whether the plaintiff or the defendant was at fault or which one was negligent, because it automatically had to be paid. So there was no common question of fact or law that needed to be decided. And the court noted at that point that oftentimes, like Christian versus Sizemore noted, that oftentimes if the insurance coverage issues are separate from the underlying tort issues, you should resolve the insurance coverage issues first because it may end up helping to resolve the underlying case through settlement. However, the court noted if the issues are intertwined, if the coverage issues are intertwined with the underlying tort litigation, then you have to postpone the decision on coverage and possibly even deny it. Now, in addition, the last thing I would say that would distinguish the Marks case in addition to that, because the claims here are vastly different than the MedPay provision, which didn't depend upon any common facts or law, is the fact that I think the court was very concerned that the one party was trying to attempt to get venue through joinder over parties upon which it did not have venue. The plaintiffs in that case had initially filed the case in Harrison County where the plaintiff resided, but none of the defendants resided in Harrison County, and the car accident happened in Pennsylvania. Energy Corporation of America was not a foreign corporation. It was a local corporation with its principal place of business, I think, here in Kanawha County, with its, I think, presiding or chief officer residing here. So a motion to dismiss for improper venue was granted. Only subsequent to that did the insurance company then file a DEC action in that venue, and then those plaintiffs tried to bring in the same defendants which had been dismissed, saying that the venue-giving defendant was the insurance company when they filed their DEC action. And I think this court found that to be legal maneuvering, which was very distasteful to it.
Well, here you are defending the judge's order to consolidate, but if they are consolidated, but the DEC action is heard separately and first, would that satisfy you?
Well, that's going to get to my next issue, which I think we need to discuss here, because when you first read their complaint, I think Mr. Williams made comments here today.
Left, but go ahead and get to that issue.
I'm sorry.
That's all right. I've been interrupting you.
Okay. When you read their writ, it appears that this case only involves intentional tort claims involving sexual misconduct and fraud. But in this case, these complaints involve regular negligence claims, including a medical malpractice, the failure to obtain informed consent, negligent supervision and retention, negligent failure to intervene, negligent infliction of emotional distress, and related causes of action, in addition to invasion of privacy and sexual harassment claims. And the defendants in this case seek a DEC action on all issues of coverage, not just the duty to defend, but the duty to indemnify. And clearly, our case law establishes that the insurance company has the burden to prove all facts necessary to render an exclusion operable, and that exclusions are construed strictly against the insurance company and liberally in favor of the insured. And in this case, since the very beginning, Dr. Matulis has argued, and this will apply to certain of the claims in the case. Some of the claims, he has argued that digital vaginal exams are a routine part of a colonoscopy. And he actually obtained some expert testimony, which I believe he submitted in criminal court, which led to his acquittal on at least several of the charges. So if the trial judge and the jury in this case finds that his actions were part of a medical treatment, those claims at least would only involve claims of whether he failed to get informed consent and claims related to that issue. And clearly there would be coverage under the medical insurance policy that West Virginia Mutual Insurance has for those claims.
You are out of time, but go ahead and wrap it up.
Okay,
Any final points that you'd like to make?
All right, and the last issue actually was sort of already mentioned by Your Honor, and that is, we believe it's disingenuous for the petitioner to say that they would be prejudiced or irreparably harmed here by having to engage in prolonged litigation, and engage in discovery possibly. Because one, as is already noted, the DEC action was pending for more than 2 years before they ever filed a motion for partial judgment on the pleadings, and then a motion to expedite hearing on the declaratory judgment action. And they only did that after we filed our motion to consolidate under Rule 42. And then moreover, as we've already discussed, it's clear that Judge Bailey was willing and able to offer a hearing. Now, I'm not saying she would determine that no discovery was necessary to be completed, and she may very well find because of the claims that the issues are intertwined and that she can't make a finding on all the issues raised therein at this time. But she's willing to have the hearing, and that's clear in the record. Thank you, Your Honor.
I think we understand your position. And rebuttal, Mr. Williams.
So it's my turn to interrupt, and my question really goes to whether we should be second-guessing in the context of an extraordinary writ the discretionary decisions of a trial court. As counsel pointed out, of course, our deference on this issue goes back to Christian versus Sizemore, but you can go all the way back to Holland versus Joyce in 1971, syllabus point 1. Context of an appeal, not an extraordinary writ, but nonetheless requiring a pretty high standard to disrupt the circuit court's decisions about managing its docket. So why should we forge into that area in the context of a writ?
Justice Walker, you are correct that the standard is abuse of discretion. And one of the circumstances that this court has held in numerous cases where abuse of discretion is appropriate for reversal and issuance of a writ is where there is a clear error, a clear misapplication. Here, Judge Bailey clearly misapplied Rule 42. Under the Pickett case, it is without question that 42A does not provide a mechanism to transfer and consolidate cases that don't have similar issues of law and fact arising from them. Now, Chief Justice Workman's questions regarding whether or not the same judge could decide those issues are correct. As I indicated in my first presentation, if in the normal rotation Judge Bailey had been assigned this case, it would have been fine as long as she maintained it separate, didn't consolidate them. And it's not just consolidating them with the cases against Dr. Matulis, it's consolidating them in cases involving CAMC, day surgery, Charleston gastroenterology, and others. There is a reason why we traditionally say that coverage matters have to be kept separate and dealt with separately. And, as my friend just acknowledged, in many cases decided first. And this is one of those cases. So, notwithstanding the fact that there's an abuse of discretion standard, if a trial court doesn't comply with the rule, and again, Rule 42A is a consolidation rule, not a transfer rule. 42B is the transfer rule. And there were cross motions under Rule 42A and 42B that were pending in front of her that ultimately were decided, and at the end of the day, when all of the orders were prepared, only 42A was what was referenced. It would be important to note that when the original Metoulas actions that had been filed and were assigned to an array of judges in Kanawha County were consolidated in front of her for discovery and for pretrial proceedings, her order, which is in page 544 of the record, found that it was Rule 42A and 42B, that the transfer was pursuant to 42B and the consolidation was under 42A.
Counsel, I would welcome the opportunity for you to clear up or point in the record. You represented on your initial remarks that Judge Bailey had made some indication that she was going to defer the deck action issue to at a later date and suggest pursue the underlying tort first. Obviously, respondent suggests otherwise. Can you point me as the basis of your representation that Judge Bailey has said she's putting off the deck action to a later, which is part of your basis for asking for the prejudice?
Absolutely, Justice Jenkins. It is in the first 5 or 6 pages of the appendix where we put as the first item her order. And in her order, she says that the issue of coverage could be assisted by the completion of discovery in the underlying matters, which is just not the case. The discovery that's going to be conducted in those tort actions to determine whether Dr. Metoulas did this or not is really irrelevant to the question of coverage. Coverage will be decided based upon the allegations in the complaint and the language in the policy only. So under those circumstances, by stating gratuitously, and it's also contained in the transcript of the hearing from which this order arose, she stated that the decision to consolidate was not based upon the fact that the cases were similar, but it was based on efficiency, which is not one of the factors that Rule 42A considers. But then in the order itself, which, as is often the case, competing orders were provided by counsel, she added into the order that she entered the plaintiff's order, but she added